So, she's your sister, right?
Yes.
So under that mask, she looks a little like you?
As much as brother and sister can, I suppose. But she doesn't have a mustache.
Yeah. Well, yeah. Let me ask you something. Has she always been a drama queen?
Oh yes, we started taking her to shows when she was 13. We lived in Las Vegas, so there was always something to see. She even tried to get work as a showgirl after high school. She loved the outfits.
A showgirl? That's good dirt.
Excuse me?
Hello. Good evening. Lady Justice here. Let me take this off so I can see you.
Oh, I loaned her that sword.
You have loaner swords.
Doesn't everyone?
You know, I've heard people say I wear this blindfold to show that justice is implied impartially. Actually, I wear it because I do not like seeing what is done in my name, especially in the Supreme Court building before which I stand. Looking at the history of the Supreme Court as I have lived it, no one can be surprised that it has again and again sided with the great against the powerless. The Supreme Court has defended slavery, segregation, economic oppression, child labor, compulsory sterilization, wiretapping, and indefinite detention. There are those who say the Supreme Court is a partisan institution. They are correct. It always has been. In fact, the power of the courts to rule on the constitutionality of laws began as a political maneuver. In the presidential election of 1800, the ruling party of President John Adams, the Federalists, were defeated by Thomas Jefferson's Democratic Republicans. While the Federalists never considered denying their defeat and seizing power, unlike some orange-faced losers, they did try to game the system. In the last 2 days of his presidency, Adams appointed over 40 judges. While most of the commissions were successfully delivered, allowing appointees to take up their offices, some were not. One of the appointees who didn't receive his commission was William Marbury. When he petitioned the new Secretary of State, James Madison, for his commission, he was refused. President Jefferson considered the undelivered commissions nullified. Marbury finally sued Madison in the Supreme Court. Now, this suit put the court in a real bind. The Chief Justice was John Marshall, a loyal Federalist. If Marshall and the court ruled that Marbury should receive his commission, it would look like a partisan move. Jefferson would have grounds to ignore the decision, which would cripple the court. On the other hand, ruling for Madison and Jefferson would hand the new administration a substantial political victory. Marshall served up a distraction. With the unanimous backing of his court, he held that withholding the commission was illegal, which pleased his Federalist allies. However, the decision went on to state that the Judiciary Act, which established the Supreme Court itself, granted the court authority which the Constitution did not allow. By striking down the relevant portion of the Judiciary Act as unconstitutional, Marshall basically told Marbury, "Can't help you, dude." So Marbury never got his commission, but Marshall gave the Supreme Court a secure future. He also created the tradition of writing majority opinions when the court ruled on a case. Many of the norms and traditions associated with the Supreme Court, possibly including the wearing of those black robes, started with Marshall.
Your sister wears a lot of black. She always done that?
No, it started after that Blanchard incident. She told me she was bitten by a radioactive goth girl.
And acquired her powers?
The moods, musical tastes, fashion sense, and proportionate strength of a 17-year-old goth maiden.
That's stupid.
Norms and traditions have generally restrained overt partisanship, but not always. For example, Marshall's successor, Roger Taney, led the Supreme Court up to the Civil War. Now, Taney and I did not get along. He was very, very pro-slavery. His court's most famous decision was Dred Scott v. Sanford, in which an enslaved black man sued his owner on the basis that, when he was taken across state lines into a free state, he was from that moment a free man and an American citizen. The court ruled that, at the time the Constitution was written, American citizenship was never intended to include blacks, and thus even free blacks could never be citizens. Taney went further, striking down an act of Congress known as the Missouri Compromise on the grounds that the territories affected by the compromise were not parts of the United States at the time the Constitution was written. At the time it was written. Keep those words in mind. Taney's defense of slavery turned even more Americans into abolitionists and brought the nation closer to civil war. Taney died during the war and was replaced with Salmon P. Chase. Now, I liked some of what Chase's court accomplished. In one case, he got to rule that secession was unconstitutional. In another case, that civilians could not be tried by the military. But the court was still a very conservative institution. For example, when a woman who had passed the bar sued for the right to practice law, the court ruled almost unanimously that she could not, saying, "The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life." What?
Delicacy my ass!
Quite. Civil rights got worse after Chase. Under Chief Justice Morrison Waite, suppression of black voting rights was okay as long as the method of suppression wasn't blatantly racist. His court ruled that women did not have the right to vote either, because there is no right to vote in the Constitution. In another ruling, his court said the federal government could not act against white terrorism directed at black Americans, and later on, he and his colleagues ruled that whites-only facilities were absolutely fine. After that, things got really bad. The next court, under Melville Fuller, initiated the period known as the Lochner era.
The Lochner? The sum of all evils?
You're thinking of the old heavy metal movie.
Yeah, and I want to know why the Supreme Court has the Lochner.
In 1897, the court ruled that the Constitution protected what they called freedom of contract. That is, every contract, including employment, is an agreement between free and equal individuals. In practice, of course, this is almost never the case. Status and wealth always play a part. A laborer with a starving family is not in a position to negotiate as an equal with potential employers. The Lochner era is named for the 1905 case Lochner v. New York, which struck down a state law setting a 6-day workweek for bakeries. For the next 3 decades, the court would take firm action against workers. For example, the Fuller Court approved anti-union action by employers. It blocked federal efforts to protect black workers from racially motivated attacks. And let's not forget it was Fuller's court that legitimized state-sanctioned racial segregation in Plessy v. Ferguson. The Lochner era continued under Chief Justices Edward Douglas White and William Howard Taft. White's court struck down a ban on child labor. It also generally supported government crackdowns on anti-war activity. Taft's court continued to defend child labor and blocked a national minimum wage. It upheld racial segregation in schools, approved wiretapping surveillance by the federal government, and okayed compulsory sterilization for those deemed intellectually disabled. The advent of the Great Depression did not change the Supreme Court's determination to keep the wealthy in charge. By this time, Charles Evans Hughes was Chief Justice, and he became the nemesis of President Franklin Roosevelt's New Deal programs. The court overruled so much legislation, in fact, that Roosevelt proposed sweeping judicial reform that would have allowed him to appoint new justices to the court. You see, back in 1914, Associate Justice James Clark McReynolds recognized that failure to retire was becoming a problem in federal courts. He proposed that when a federal judge reaches retirement age but does not retire, the president should appoint an additional judge to the elder judge's court to share the burden of the court's work.
They were talking about that 100 years ago. They should have done it.
Roosevelt built on this idea when he announced a plan for judicial reform. Centrists and conservatives mobilized against the proposal, deriding it as packing the court. At the same time, the Supreme Court changed direction, upholding a minimum wage law for the first time and ruling the creation of the National Labor Relations Board as a proper regulation of interstate trade. These two rulings removed the urgency behind Roosevelt's efforts, and judicial reform went no further. Now, Roosevelt was president for 12 years. By 1945, he had appointed almost everyone on the Supreme Court. But this was still not a great court. It was this court, under Chief Justice Harlan Stone, that supported the internment of American citizens of Japanese ancestry. The next court, under Fred Vinson, was also pretty conservative, but some good came out of it anyway. It struck down racial restrictions in housing covenants, for example, and prohibited the establishment of religion in public schools. None of these courts were particularly liberal or progressive. So what is this judicial activism about which conservatives complain? Mostly, it's the legacy of the Supreme Court's decisions under the stewardship of Chief Justice Earl Warren. At the time of his appointment to the Supreme Court in 1953, Warren was a highly respected figure. He had been elected governor of California in 1942 as the Republican nominee, and was re-elected in 1946 as the nominee of the Republicans and the Democrats. He ran for a third term in 1950 and won that too. No one before or since has served 3 terms as governor of California. President Eisenhower appointed Governor Warren to the Supreme Court in 1953. Though not a judge, and his legal writings were not the best, Warren was a leader and a great believer in American ideals. His genuine belief in justice placed him with the wing of the court that favored individual rights. It was the Warren Court that unanimously struck down legal segregation and laws against racial intermarriage. This is the court that established the principle of one person, one vote, that required police to inform suspects of their rights, that prohibited sectarian school prayer, that legalized contraception, that applied the Bill of Rights to the states.
Lady Justice has a boyfriend! Woo!
You bet, girlfriend. My boy Warren wanted his court to be remembered as the People's Court. Throughout the 60s, his court continued to issue decisions defending civil rights. You can see why this infuriated conservatives. Granting rights to the unwashed masses? The horror. When Warren announced his pending retirement in 1968, Republicans blocked the appointment of his successor. They absolutely would not allow a Democratic president to make a Supreme Court appointment in an election year. Richard Nixon won the election. Despite his reluctance to let Nixon appoint his successor, Warren decided to follow through on his retirement in order to avoid giving the impression that the court was a political entity. You know, I've been sitting here for a long time talking about the court as a political entity. People put so much effort into maintaining this pretense that the court is a nonpartisan institution, despite decision after decision proving otherwise. That Earl Warren, whose court promoted equality, democracy, and individual rights, should have participated in maintaining this facade is tragic. Nixon appointed Warren Burger as Chief Justice. Burger was conservative, but also had a respect for legal precedent. Nixon appointed 3 associate justices as well, but Burger's court overall maintained Warren's precedents and even built on them. Burger's court supported freedom of the press and allowed publication of the Pentagon Papers. It struck against whites-only schools, known as segregation academies, by allowing the revocation of tax-exempt status from any educational institution that practiced racial discrimination. And in a decision that resonates to this day, the Burger Court built on the right to privacy that the Warren Court had found within the 14th Amendment and legalized abortion in the Roe v. Wade decision. It was a 7-2 decision. One of the 2 dissents said that the court had no right to weigh the relative importance of the fetus on one hand and the impact on the woman on the other. The other dissenter said that since abortion was restricted in most states when the 14th Amendment was ratified, protecting abortion rights could not possibly have been the original intent of the amendment. The justice who wrote that dissent was named William Rehnquist. It is with him that the Supreme Court starts to go badly wrong. I don't know about you, but I could use a drink. How about we take a little break, a little entr'acte, while I make myself a cocktail?
Well, what do you think so far?
Brilliant.
Makes me mad to think that we think of the Supreme Court as upholding law and order, and instead they're like this.
Like what?
Like a bunch of schmucks. I wish Americans would just wake up and make changes. Her going over the history of the Supreme Court makes me so damn angry. Your sister drives me crazy with her outfits, reading in her brain.
She is a little over the top, but it's interesting.
I'm not bored.
Uh-oh, looks like she's coming back for more.
In 1982, conservative law students from Yale, Harvard, and the University of Chicago founded the Federalist Society. This organization promotes an originalist interpretation of the Constitution. This means that every clause and amendment should be interpreted as meaning what they meant at the time they were written. At the time they were written. There's my old nemesis, Taney, come back to life. You know, the Constitution was written by and for the benefit of rich white men. If you only read it with the original intent, then only rich white men will benefit. Rich white men like the founders of the Federalist Society. For example, if you look at what the writers of the 14th Amendment thought, they weren't interested in full racial integration, only in granting basic citizenship to freed slaves. If you take that position, then you can say that my boy Warren was wrong to order school desegregation. The society is well funded by white male billionaires because of its excellent network of chapters and its success at getting its members appointed to state and federal courts. It has evolved into the career gateway for conservative lawyers, as long as those lawyers toe the Federalist Society line. A lawyer groomed through the society ends up espousing pretty much the same ideology as any other society lawyer. They are an ideological hive mind, an epistemic community of identical clones. If these clones get their way, they will resurrect a world in which only white men had full legal rights. The Federalist Society had been turning out its fat-grown conservative pod people for only a few years when Warren Burger retired. His replacement was that man I quoted a few minutes ago, William Rehnquist. William Billy Boy Rehnquist. Willie Billy Rehnquist. You know, the one who said that we couldn't legalize abortion in 1973 because it was illegal in 1868. That guy. Billy Boy had been a law clerk at the court in 1952 when the court was ruminating about school segregation. He wrote a memo supporting segregation, saying, "It is the majority who will determine what the constitutional rights of the minority are." That's right, he wanted the human rights of politically powerless groups to be subject to a vote by those who already had power. Like that would go well. Free Willy and I were not on good terms. He was not interested in justice, only in power. Namely, protecting people who had power and denying protection to those who did not. He lived by that 1952 memo, you see. No, we did not get along, he and I.
I wish Lady Justice could come alive and kick his ass. Sounds like he really needs it.
So what, specifically, did he do that drove such a wedge between the two of us? Well, there was the Casey decision, a very messy decision with no court majority. It allowed states to impose arbitrary restrictions on abortion rights. Bill and 3 associate justices tried to overrule Roe entirely, but they were unable to persuade any of their other colleagues to join them. It may be that Roe was saved by the first woman appointed to the Supreme Court, Sandra Day O'Connor. We'll hear from her again. I also didn't like it when Billy led a 5-4 decision striking down the Gun-Free School Zones Act of 1990. I mean, who looks at a school and says, you know what would help educate these kids? Some guns. Billy also led a 5-4 decision that struck down part of the Violence Against Women Act of 1994, specifically the part that allowed victims to sue their attackers in federal court.
Oh, that son of a bitch!
You understand what I'm talking about. All these are bad, but the worst case to come out of Billy Boy's court was Bush v. Gore. In the 2000 presidential election, Democratic nominee Al Gore received a plurality of votes, nearly 51 million. Republican nominee George W. Bush received just under 50.5 million. Of course, because of the bizarre way in which presidential elections are held, the winner is determined on a state-by-state basis in the Electoral College. Bush had 255 electoral votes, Gore had 246, later increased to 267 when all the ballots in 2 close states were counted. However, in Florida, where Bush's brother was governor, and where his state campaign chair was also in charge of counting the votes, each candidate received just over 2,900,000 votes, with only a couple thousand votes separating the 2 candidates, determining the winner of the state's electoral votes, and thus the presidency depended on a recount. Preliminary recounts shrank the difference to a few hundred votes. On November 22nd, Republican staffers and lawyers violently shut down a recount in Miami-Dade County in an event called the Brooks Brothers Riot. Florida's Supreme Court had allowed the recount to continue, and on December 8th, the Florida judges ordered a statewide manual recount of all ballots for which a machine reading did not produce a result. The very next day, Billy and his minions ordered the recount stopped. 4 days later, the Supreme Court issued its decision appointing Bush to the presidency. Bush v. Gore is an anonymous decision, and a convoluted one. Well, twisted, really. The decision argued that since there was no statewide standard for how to conduct the recount, voters were being denied the equal protection of the law. However, because the recount had been stopped so often, and because of unspecified complexities, there was no longer time to set standards and perform a recount.
Oh, come on! They're the ones who stopped the fucking count!
The lack of recount standards was a genuine issue. Even Democrats on Florida's Supreme Court agreed with that. But instead of demanding statewide standards for a final recount, Rehnquist and his 4 conservative colleagues instead ordered an end to all recounts, thereby making Bush, the nationwide runner-up, president-elect. There is little doubt that this was a partisan remedy. 2 justices, Billy Rehnquist and Sandy O'Connor, had expressed interest in retirement if their seats would be filled by conservative appointees made by Republican presidents. The wife of one of the conservative justices was involved in the Bush campaign. The son of another argued for Bush in the case that gave Bush the presidency. Wicked Bill Rehnquist died in 2005. His successor as Chief Justice was John Roberts. Bill was partisan, but he's got nothing on Johnny Boy. John Roberts has been a real strategic thinker when it comes to advancing the goals of the Republican Party. He'll graciously give the occasional victory to the court's liberal wing, but only if it won't distract from his main goal, defending America's moneyed aristocracy from the rabble. The Roberts Court has consistently sided with the great against the powerless. He has led the court in opposition to efforts expanding educational opportunities for non-whites, saying, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." He authored a nonsensical ruling that allowed states to opt out of Medicare expansion, resulting in the deaths of thousands of people. His court limited abortion rights on the basis that Rehnquist's court had already allowed some restrictions. His court allowed a plainly unconstitutional abortion ban to go into effect, and to really demonstrate his pro-life credentials, his court became the first one to rule that the Second Amendment means anyone can own a firearm for any reason. I see your faces. You're wondering why firearms are a pro-life thing. I honestly don't know, but supporting gun proliferation and opposing abortion rights go together for some reason. Anyway, all that aside, Robert's main focus has been expanding the political power of the wealthy and limiting the power of everyone else. He has never seen a voting restriction he didn't like. He has never seen a campaign finance law he would let stand. The man is determined to keep the American people under the control of their betters. Consider the Citizens United case from 2010. By a one-vote majority, the court ruled that there could be no restrictions on corporate political donations because money is a form of speech, and restricting how someone uses money is therefore a restriction on speech. In 2014, Roberts' court went further, removing restrictions on the total amount of money individuals could donate. At this point, there are almost no remaining limitations on how the wealthy can use their money to influence politics. In 2013, the Shelby County case came before the Roberts court. By a one-vote majority, in an egregious decision written by Roberts himself, the court practically declared a part of the Constitution itself unconstitutional. The 15th Amendment states that the right to vote shall not be denied on the basis of race, and that Congress has the power to enforce the amendment. For 100 years, former Confederate states did everything they could to deny blacks the right to vote based on their race. Congress finally acted to enforce voting rights in 1965, and required states with a history of discriminatory voting laws to get federal approval before changing them. In his ruling, Roberts wrote that states which had suppressed black votes before the Voting Rights Act of 1965 were being treated differently from those who had not, which was unconstitutional because federalism or something. Basically, Roberts argued that because states which had practiced voter suppression could no longer practice voter suppression because of the Voting Rights Act, there was no point in enforcing the Voting Rights Act. I'm not exaggerating. He praised the act for successfully fighting racial discrimination, and then demolished it. Literally within hours of the court's decision, Republican officials in Texas and Mississippi announced they would be enforcing strict new voter ID laws that would disproportionately impact the poor, especially non-whites. Roberts has since gone on to make things worse. In 2019, his court ruled on gerrymandering. Remember, gerrymandering is the practice of politicians drawing lines on maps to favor themselves and their parties. Instead of voters picking their politicians, it's the politicians who pick their voters. And guess what? Roberts is a fan of it. By a one-vote majority, the court ruled in a decision written by Roberts that gerrymandering may produce unjust results, but courts can't fix injustice. If people don't want politicians to gerrymander, they can elect politicians who won't gerrymander. Except, of course, because of this decision, they can't. There are a handful of states which are no longer functional democracies because of gerrymandering. In the 2018 elections, Democrats won a majority of votes for the North Carolina state legislature, but the Republicans still kept most of the legislature's seats.
They suck.
You should not have served alcohol in the lobby.
There's no alcohol in the lobby.
Also, there's no lobby.
Wisconsin's gerrymandering is even worse. The popular vote has no real effect on the state legislature. For Democrats to gain a one-seat majority in the state assembly, they would have to get well over 60% of the vote. The Roberts Court is the court which is active today. You'll notice that a lot of the court's worst attacks on voting rights were decided by a one-vote majority. However, as a result of Republicans packing the court with reactionaries, it has become even more hostile to civil rights, especially voting rights, in the last few years. The Roberts Court shares the Republican Party's overall hostility to democracy and favors an unaccountable oligarchy. The Supreme Court is overturning laws that protect American democracy. It is defending Republican efforts to eliminate competitive elections. The partisan nature of the Supreme Court is so blatant that only 30% of Americans consider the court's rulings fair. Several members of the Supreme Court have protested this perception. Justice Thomas claimed that he and his colleagues never rule based on personal partisan preferences. Justice Barrett, whose confirmation was rushed through in the weeks before the 2020 election, expressed her concerns on the matter. Justice Alito claimed that the court's conservatives are victims of an effort to discredit them and the court, as if they needed the help. Now, if you'll excuse me, I need to take a belt of this drink.
Oh, I hope she was going to take it off on stage. The mask, I mean, not everything.
She doesn't do striptease.
But she did want to be a Vegas showgirl. I can't get over that.
Does anyone need refreshments?
No, I'm good.
Nope.
Good. I can't get you anything anyway. So this is where we are. This dire state of affairs raises the question, what do? If we do nothing, Republican appointees on the Supreme Court, indeed, Republican appointees throughout the entire federal judiciary, will remain in place. If the courts truly were impartial, this would not be an issue. Indeed, if the judges had been appointed by presidents elected by the American people, it would not be an issue. But right now, 5 of the 9 members of the Supreme Court were appointed by presidents who did not win the popular vote. Well, technically, George W. won the popular vote in 2004, but he wouldn't even have been the GOP candidate if Gore had become president in 2001. And the real problem with Republican-appointed judges is that they are vat-grown Federalist Society clones. They are not impartial. They have a mission. Also, they are not very smart. In November 2021, one of these clones issued a stay order against a federal mandate that all healthcare workers be vaccinated against COVID-19. His reasoning? If boosters are needed 6 months after being fully vaccinated, then how good are the COVID-19 vaccines?
Oh my god.
Yes, a federal judge wrote that. You don't have to be smart to be nominated to the bench. You just need elite credentials and Federalist Society connections. If nothing is done, these elite dummies will continue to undermine the rights of Americans and the ability of Americans to choose their leaders and representatives and hold them to account. So doing nothing is not an option. What is to be done? One option that has been floated is legislative limits on what federal courts can adjudicate. Congress has the constitutional authority to limit the jurisdiction of the courts, and even of the Supreme Court. A problem with this is that it is unclear how such limitations would work in practice. Which questions of law could be appealed no further than a circuit court, a district court? Limiting jurisdiction could also make securing civil rights more challenging. For example, right now, if you're pregnant, you technically have the right to an abortion, but thanks to the Supreme Court, you may live in a state that requires you to, recite the Bible from memory before you get one. If the Supreme Court is barred from ever ruling on abortion again, how does this most recent ruling get overturned? Can it be done legislatively? If so, will a lower court be able to rule on the law? Limiting jurisdiction for the Supreme Court and not for others also creates a problem of patchwork law. If district or circuit courts disagree on matters of law, then who resolves those differences? On the civil rights issue, we've seen how certain states will deny rights that other states grant. This could happen again at the federal circuit level. Instead of limiting jurisdiction, the terms of judges could be limited. The Constitution says that federal judges shall hold their offices during good behavior, so a lifetime appointment unless they're naughty. But the Constitution doesn't mandate that the judges remain at the posts to which they were appointed. Originally, Supreme Court justices also served on federal circuit courts, an arrangement that lasted for over 100 years. There still remain questions of how long a term. At America's founding, life expectancy for middle-aged professionals was such that Supreme Court justices served on average 10 years, retiring before age 60. These days, it's not uncommon for a justice to serve for a quarter century or more and retire at nearly 80 if they aren't carried out feet first.
Lady Justice has a sword. Why didn't she just walk into that building and take out those fuckers?
It is possible for Congress to build on this bygone standard of circuit rotation. Perhaps after a term on the Supreme Court, a justice would be rotated out to a circuit court and serve a term there. This would also bring the United States more into line with other democratic nations which have Supreme Courts. In no other country are the members of a Supreme Court allowed to occupy their posts indefinitely. Of course, there are problems with term limits too. In states with term limits on legislators and other officials, it's not uncommon for an individual to treat their time in a given position as an audition for higher office or private employment. Term limits can also rob an institution of its memory and its competence. Even a smart guy like Earl Warren relied on his more experienced associate justices when he was first appointed to the court. And of course, it does nothing about the problem of the existing reactionaries in the federal judiciary. They will still be there. They will still be able to do harm to civil rights, workers' rights, human rights. As a result, there is some discussion of an approach like Franklin Delano Roosevelt's proposal to reform the judiciary, adding members to the Supreme Court. Opponents of the measure still deride it as court packing, but consider that conservatives have been packing the court for decades. Conservative judges have planned their retirements to coincide with conservative presidencies so that their seats can be filled with their ideological cousins, or in the case of the current ideologues on the court, their identical clones. In contrast, centrist judges have been more lax in their retirement planning. My boy Warren retired against his better judgment and let Nixon appoint his successor. Ruth Bader Ginsburg declined to retire during Obama's presidency despite being in her 80s, and her successor is undoing all her work. Stephen Breyer, also in his 80s, has rejected calls to retire during Biden's presidency. He is hoping a Democratic president will be allowed to appoint his successor. Opponents of this approach warn that there would be no preventing a future Republican president and Congress from adding their own seats to the court. Again, Republicans are already doing this. In the Senate, Republican leader Mitch McConnell deliberately kept judicial posts vacant during the Obama years, including one Supreme Court seat. This effectively shrank the size of the affected courts. Those courts were then expanded back to their usual number of seats when Trump began appointing judges. Another complaint is that it would cause the public to see the Supreme Court and the judiciary as just another political institution. Again, the Supreme Court is a political institution and always has been. On that basis, I don't think the complaint holds up. Better that its political nature be out in the open rather than hidden.
Amen!
I know how these solutions must sound. Radical. I know people are thinking of all the ways these reforms could go wrong. But the judiciary is already going wrong. For 70 years, ever since Brown v. Board of Education, reactionary individuals and organizations have been trying to bring the federal judiciary under their control, especially the Supreme Court. This has largely succeeded. The billionaires who funded the effort grew up in an America where white, wealthy men like them were the unquestioned top of the hierarchy. How it must have rankled them to see black people and women and poor people granted a tiny crumb of the liberty and respect that used to be theirs alone. How they must have hated being told by the federal government that they had to treat their employees decently, and the ultimate horror, being forced to pay for it out of their own vast fortunes. Originalism is nothing more than the conceit that since the Constitution was written by rich white men, it can only be interpreted to benefit rich white men. If you know me, I've very often been at odds with rich white men. Very few of them believe in me. Very few of them believe in America, or in American ideals like democracy, rights, liberty, and equality. Where America has failed to live up to those ideals, it has again and again been because of these people. What do I think should be done? I'm just an abstract concept. It's up to actual human beings to decide on a course of action. Personally, as Lady Justice, I'd like a combined solution. The courts should immediately be packed with enough real people to outnumber the Federalist Society clones. Any delay will erode American democracy still further. Judges should serve fixed terms on any particular court before being rotated out to another court, or to an inactive or advisory role. Lastly, the Supreme Court should consist of circuit court judges, each brought in for just a few years. On the other hand, maybe I'm not being practical. As Lady Justice, I probably shouldn't admit this, but I haven't been entirely impartial here. You see, I liked it when the justices of the Supreme Court rode circuit. Getting out of that ivory tower in the Capitol, seeing the rest of the country. You know the current Supreme Court building is less than 100 years old? Before that, the court met in the Capitol building, and before that, it didn't meet in any one particular place for more than a decade. I'm not going to pretend it was easy riding circuit. That first Supreme Court in the 1790s, on the road 7 or 8 months at a time, justices were robbed, they spent time away from their families, and weather or poor navigation could stop them dead. Why, Samuel Chase was almost drowned in a flood, but they were among the people. It's the 21st century now, and travel is faster and safer than ever. There's no reason we couldn't ride circuit together again, the judges and me. I remember when William Cushing had no friends with whom he could stay the night. The inn he chose packed him into a room with a dozen other men. And then there was the time James Iredell slummed it at an inn packed with young men who drank and gambled all night long. Heady days for Lady Justice. And I reckon it's right to want to do it all again. Wouldn't you, folks? Wouldn't you? So what did you think?
It was good.
I'd broadcast it.
Oh, it makes me mad to think about the history, but I did like you going over it.
Be honest. What did you really think?
Already said. Pissed me off.
I'd still broadcast it.
You can broadcast anything.
True.
Honestly, I liked it. But I think what you say is so good, you don't need to dress it up in all this dramatic whatever. Be yourself.
Oh, but I like the dramatics. Speaking in character is more fun. Better than just being a talking head. Nothing wrong with talking heads.
You could tell my favorite parts. I shouted from the audience.
You were a more active audience than I expected. That was nice, actually. Well, thank you for coming. I had fun. Maybe next time I'll write a play.
Oh, can I be in it?
Sure.
So, your brother says you got a thing for Vegas showgirls.
He said what?
Uh-oh.
Well, that was fun. She worked very hard on this. I hope people like, comment, and subscribe so that she is encouraged to do something like this again.